Okay, everyone, we said 2:05 start time. Thank you for being on time. Mike, are we good to go? Give me a thumbs up. All right. Well, first of all, I want to welcome and thank everybody for joining today for this really important discussion that we're going to have about the Click to Cancel initiative, and make a special note that this is exclusive for HFA members as a member benefit. So for you to really get the value of your membership and to have a leg up on maybe folks that aren't quite as informed or have the access to Mike and the team. So I want to first by start saying that this is a major win for this industry, and it really is a result of targeted efforts from both our membership community and from our staff. So again, Mike, who's been at the helm of this with a coalition in DC and is doing a tremendous job. So thank you so much. But it's also important that we talk about that it's not going away. This is far from over. We were able to halt the implementation of this, but we're going to live to fight another day. But again, that's not over. And we're going to talk about ways that you can help do that. So what do we see that's coming next? Most immediately is going to be pressure in the states. And so again, we'll talk a little bit more about that and what that looks like and how Charles from our team can help lead and inform on conversations like that. But today, I want to thank the folks from Gibson Dunn for joining us who have really are experts in this, and they're going to talk about what we can do now to keep ourselves protected in the immediate future as we continue to fight. So with that, anything I missed, Mike, or are we going to turn it over to the folks?
Yeah, just some quick housekeeping items. As the team is presenting, please feel free to put questions into the chat. There'll be a question and answer portion at the end where we'll be able to relay the questions to the team just to streamline the process and make sure everybody's issues get addressed. And of course, at the end and after this, the recording will be made available. But if there's any questions and follow-up, you can reach out to our team. Svetlana and the team at Gibson Dunn will also make their contact information available for members to reach out individually if there's any questions. So with that, Svetlana, I'll turn it over to you and for further introduction to kick us off.
Great. Thank you, Mike, and the entire team for hosting us this afternoon. This is a very important topic that everyone should know about, given it is a high priority at the Federal Trade Commission for enforcement of ROSCA and the subscription space. So as Mike stated, my name is Svetlana Gans. I'm a partner in the DC office at Gibson Dunn. I served as the FTC Chief of Staff in the first Trump administration and spent 8 years at the commission and other roles litigating these cases. With me is my colleague, Kaylin. She is an expert in the consumer protection space here at Gibson Dunn, and we will be walking through what we're seeing as key priorities in this space at the Federal Trade Commission in the states, and as Mike said, how you could protect yourself going forward if you do face an investigation from either entities. So with that, Kaylin, if we could just go to the slide on the ROSCA slide. So given the time, I just want to make sure that we have all your questions answered at the end of the portion. And as Mike said, please feel free to post any questions in the chat. We'll try to get to it today. So as folks are familiar, the ROSCA, the Restore Online Shoppers Confidence Act, was passed in 2010. There continues to be aggressive FTC enforcement of that statute. As a refresher, there are three main requirements of ROSCA, which govern auto-renewal and other contracts where the customer does not have to consent every time to get a recurring payment. They just have to do that one time. So ROSCA imposes three requirements on direct auto-renewal contracts. One is clear and conspicuous disclosures of the material terms of the negative option feature. Two, express informed consent to that enrollment. And three, a simple cancellation mechanism. So those are the three basics of the ROSCA statute. Violations of ROSCA exposes companies to civil penalties, which right now are over $50,000 a day per violation. It could also expose companies to restitution claims from the Federal Trade Commission as well. The FTC has strict interpretation requirements of the statute, as we will talk about later in this session. Next slide. So why did the FTC decide to add another rule as to negative options, it is because the framework that the FTC had earlier was fragmented and only impacted certain industries and not all. So the FTC under the Biden administration sought to promulgate the negative option rule that would apply across all industries. They proposed it in April of 2023. They finalized it in October of 2024, and they promulgated it in November of 2024. As you may recall, the initial proposal was a bit more daunting than what was ultimately adopted, but even the ultimate adopted version was still pretty onerous for the industries and imposed several requirements that would make it hard for companies to offer negative option programs, which are quite standard in the industry at this point. So what were the key distinctions between ROSCA and the negative option rule? A few. First, the negative option rule would have required a separate consent requirement for the negative option as opposed to the other requirements. It would require specific sign-up disclosures. And most importantly, for our purposes, for the FTC Republicans, is the cancellation must be as easy to use as sign-up. What the ROSCA rules did not have a specificity on what easy cancellation method was. And so the negative option rule provided more specificity around what an easy cancellation method is. Importantly, the negative option rule also allowed the FTC to get civil penalties, but it expanded Section 5 of the FTC Act, which is the FTC's general purpose statute, that any violation of the negative option rule would also, if there was a misrepresentation unrelated to the negative option feature, the FTC could get civil penalties for that. Generally speaking, the FTC cannot get civil penalties for Section 5 because it is a generic statute and not very specific. And that is why the courts have limited the FTC's ability to get civil penalties only for rule violations. So this was a significant expansion of FTC authority to get civil penalties for misrepresentations unrelated to the negative option feature. As folks recall, the rule was promulgated over the dissent of the Republican FTC commissioners, and you all were quite active in the space, filing a comment in June. IFA, whom I represented, testified at the FTC informal hearing concerning the proposed rules, costs, and benefits, particularly focusing on the fitness industry, given that it would be hard to adopt many of the proposed rules, dual consent requirements, as well as the easy cancellation as defined in the proposal. Next slide. So Gibson Dunn, as some may know, led the challenge to the negative option rule. We were kind of there every step of the way. We represented a variety of petitioners in that challenge, including the Chamber of Commerce, NCTA, and the Interactive Advertising Bureau. We challenged the rule on three specific grounds. One was that it exceeded the FTC's statutory authority because it lacked specificity and did not meet the prevalence requirement because it was economy-wide rather than distinct. As you may recall, the agency's cost-benefit analysis also did not focus on particular industries. It was quite broad in application. We also argued that the FTC failed to follow the required procedure at the FTC. As you may know, this rule was brought under the Magnuson-Moss Act, which is Section 18 of the FTC Act, which requires the FTC to go through a few more steps in terms of regulations above and beyond what the APA requires of other agencies. So we allege that the FTC failed to follow certain steps of that statute. And then we also argued that the rule was arbitrary and capricious. And again, you all were very involved at that stage, again, filing amicus briefs in support of the vacator of the rule, which we of course greatly appreciate. So the Eighth Circuit just recently held a few weeks ago that the FTC's rule basically vacated the rule, finding that the FTC failed to follow the requisite procedure under Section 18 when promulgating the rule. And the court found that step that was failed to be followed is called the preliminary regulatory analysis step, where the FTC has to provide for public comment an analysis of the costs and benefits of the rule, as well as regulatory alternatives to that rule. As folks following this proceeding may have remembered, when the FTC initially promulgated or announced this rule earlier on, it stated that it did not believe the rule would cost the industry more than $100 million. That is the threshold after which the FTC must do a preliminary regulatory analysis. When this matter went before the administrative law judge, as you may remember, the administrative law judge actually sided against the FTC and found that the rule indeed would cost the industry, and these are the entire economy, not just your industry, but the entire economy, over $100 million. And because of that, they were required to conduct additional analysis. So at that time, based on the administrative law judge finding and reversal of the FTC's burden analysis, we were thinking the FTC would come back with a regulatory analysis as required by Section 18. But alas, the FTC did not, and went ahead and proceeded to just file a final regulatory analysis and omitted that key procedural step. Anyone that is subject to an FTC consent order or is trying to ascertain FTC rules as to what they mean and whether to follow them or not, it is interesting to me, at least being a FTC observer, that the FTC stated or argued at the Eighth Circuit that its failure to follow the FTC procedure was harmless error. I find that a bit funny because the FTC is very particular in terms of regulated entities following the laws to the T. So they argued that their noncompliance with FTC procedure was harmless error, which the court disagreed with, and said that, that actually it was an important step in the process, and you can't just say, well, it was harmless error. The industry should have just, not worried about it and submitted its comments in conjunction with the final regulatory analysis. So it was just interesting that they had that the defense of harmless error based on their regulatory body. So now the big question for us is, will the FTC appeal? They have until late August to file an appeal, or, we will see what happens. As some may remember, both Republicans dissented with the rule initially, but we are hearing now and have heard for some time that the Republican commissioners do agree with some facets of the rule, in particular, the clearer articulation of the easy cancellation requirements. And so we will see whether that admiration for those specific provisions will offset the good win on a process point that the FTC has now with respect to rulemaking going forward. So I give it 50-50 chance that the FTC, less than a 50-50 chance that the FTC will challenge the holding, but we will see what happens. And then otherwise, you probably saw that Commissioner Slaughter tweeted when she was reinstated, her first day back into the office, she stated that she's going to be protecting consumers from the real abuses and getting the click to cancel rule back on track, and calling for a vote to restore it. Now, that intention was short-lived because the DC Circuit just a few days later decided that they stayed the district court decision that found that her firing was unlawful. So we will see what happens with respect to Commissioner Slaughter's return back to the FTC, but all eyes right now are on the FTC Republicans to see what they'll do in terms of appealing or not. Next slide. So in lieu of having a new negative option rule to enforce, the ROSCA remains a key priority of the FTC, and the health and fitness space also remains a top priority for the agency because they did get several complaints during the rulemaking process and otherwise concerning alleged ROSCA abuses of the industry. So, this is why we wanted to have this webinar to talk through some of the requirements and some best practices in the industry. Next slide. So the FTC has been very focused on the ROSCA space. There have been 3 major court cases that are actually being litigated right now as to ROSCA. And if you recall, historically, folks did not really litigate against the FTC, but folks started to challenge some of their proposed consent orders and complaints. And so now we have 3 cases in litigation right now. As to ROSCA in particular, it's the Amazon Prime case, the Adobe case, and the Uber One case that was most recently filed. Interestingly enough, the Amazon and Adobe both filed motions to dismiss their cases, and the courts denied those motions to dismiss, finding that the FTC had sufficiently pled that the defendants did not provide clear and conspicuous notice to consumers of the negative option feature. So I don't want to go through all of these because I want to leave time for questions, but I did want to highlight a few things in terms of what I found interesting with at least the motion to dismiss decisions from both Amazon and Adobe. So in Amazon, as you may recall, the FTC is alleging that the company failed to disclose the material terms of the subscription clearly and conspicuously, and that the company failed to obtain consumers' informed consent before enrolling them. And in rejecting the defendant's motion to dismiss, the court found that the courts look at both state and federal law to determine whether disclosures are clear and conspicuous, and that California courts have held that when a consumer is attempting to start a free trial, especially when it is offered as a gift, it is much less likely that the consumer would scrutinize the page with small text outside of the payment box or at the bottom of the screen, linking them to 26 pages of contractual terms. For auto renewals in particular, the context is most important. They also noted that courts rarely dismiss complaints on motion to dismiss for clear and conspicuous grounds because usually where a business practice is deceptive is generally a matter of fact requiring the weighing of the evidence. So for that reason, the courts rarely grant motion to dismiss based on whether or not a reasonable consumer would have understood the disclosures in a negative option offering. That case is also interesting because it talked a little bit about individual liability issues, and I'm happy to answer questions about that at the end. Next slide. Adobe, similar allegations that Adobe failed to disclose the negative option feature clearly and conspicuously and did not receive informed consent from the consumers. What I found interesting in Adobe is that it has a lot of the subscription sign up features as probably you do and other companies do. Adobe allowed consumers to both cancel their subscription online and also via chat or by phone with customer support. So that was a good fact. However, the court found that although the cancellation was available online, the interface to navigate that cancellation process, which required customers to click on several more pages and required them to switch between different passwords, was problematic. The court also found that After the consumer clicked on cancellation, they were presented with other save opportunities and other products to potentially purchase. And so the court found foul with that, at least at the motion to dismiss stage. And although the Adobe offered consumers a cancellation method by phone or by chat, that method also required consumers to go through several hurdles to speak with several representatives and also included save opportunities. It is interesting that that this court focuses on save opportunities. As you may recall, the FTC's negative option try to curtail save opportunities, but that provision was taken out of the final proposed rule. But it is interesting that the courts are still looking at save opportunity as somewhat problematic. The court also looked at the cancellation fees and found that the EFTs associated with the plans were not conspicuously disclosed because they were on the bottom of an optional hyperlink terms page that consumers are unlikely to see. So again, as you're going through your own policies and procedures and your consumer interfaces, these are the types of things to be mindful of in terms of compliance with ROSCA. So if you go to the next slide, we're going to skip Uber one. That is similar allegations, and it is currently in litigation. Uber did not file a motion to dismiss, but they are instead filed an answer in June. So again, 3 key cases will be interesting to see what happens in the courts. So with that, let me turn it over to Kayla and talk about state law.
Yeah, so as we noted at the outset, this is also an active area of interest for the states. A lot of states have passed laws recently or amended their laws. There's more than 30 states that have broad automatic renewal laws that apply across industries. There's other states like Washington that have recently considered passing such legislation, so there's still bills that are pending. Most of these laws are business to consumer only, so they won't impact business to business transactions. And as I noted, many of these laws are relatively recent. Massachusetts has a regulation that goes into effect in September. California and South Carolina recently updated their existing laws. And Minnesota, Virginia, and Utah enacted new laws. These laws typically impose either more stringent requirements than ROSCA, or they are more specific, and a lot of them will apply outside of the online space. So they'll apply to in-person or telephone transactions. Each state is a little different. They'll have their own requirements on what terms need to be presented to consumers, how they need to be presented to consumers, how long the auto renewals can be, and then specific requirements about sending reminders before contracts renew. So in particular, there's some variance as to what constitutes clear and conspicuous under these laws. For example, in Vermont, there's a specific requirement that any term in the contract that talks about auto renewals needs to be bolded and in 10-point font. Some laws will cover cancellation, like the negative option rule, but others won't regulate them at all. So for example, Utah requires businesses to disclose how to cancel at sign up, but doesn't otherwise regulate how cancellation occurs. And then there's other variants about whether or not you need to send a confirmation record to consumers after they sign up, or whether you need to send a reminder to consumers in advance of any renewal term. For example, California requires an annual reminder for subscriptions that has to be sent in the same medium that customers use to interact with the service. And Virginia requires reminders if the renewal period is longer than 12 months and requires that reminder to be between 30 and 60 days prior to renewal. Some of these states, including California, Vermont, and Virginia, have requirements that look a lot like the negative option rule by expressly requiring affirmative consent or express affirmative consent, or requiring businesses to allow consumers to cancel online if they were able to sign up online. There's a number of state enforcement actions that have been vigorously enforced, particularly against fitness companies. For example, New York recently announced a large settlement with Equinox related to its subscription practices, and the District of Columbia's Attorney General has sued one DC gym a couple of times related to its cancellation policies, including its cancellation policies over COVID. To sort of zoom in here, we'll talk a little bit about California's law specifically because it's one of the most strict laws, particularly because they passed stricter amendments that went into effect on July 1st. These amendments include a requirement to get express affirmative consent, which it's not entirely clear what that means, but it does mean that really key terms need to be disclosed clearly and conspicuously to users at sign up. And it also requires that companies keep records of the consent for at least 3 years. And then it requires clear and conspicuous notice of material terms like the length of any auto renewal period, the price of the service, if the price of the service is going to change and what it will change to if it does, the length of the term, the cancellation policy, and any minimum purchase obligation. It also imposes strict rules about free trial periods, including requiring an explanation of the price that will be charged after the free trial ends. It limits how businesses can offer cancellation. Specifically, if users sign up over the phone, they need to be able to cancel on the phone. If users sign up online, they need to be able to cancel online. It also limits the number of save opportunities that businesses can offer. It says that if you offer a save option, you're allowed to do so, but you have to allow users to promptly cancel. If they say the word cancel on the phone, or there needs to be a cancel option on the screen. It also requires basically email notice of material changes in terms, including price changes. Depending on the change, you might want to talk to a lawyer to see if you need something more than an email. And then it requires annual reminders for any annual subscriptions in advance of the renewal date. In addition to these more general terms, there's more than 20 states that have laws that specifically regulate health and fitness clubs and their auto renewal laws. For example, Iowa has a law that prohibits health and fitness clubs from having auto renewal terms. Other states will have requirements that require gyms to have written contracts or allow cooling off periods to allow users to cancel their membership within 3 days of signing up, or another time period depending on the state law. There's often term limits to how long the auto renewal period can be, somewhere usually between 24 and 36 months. And then they might require express consent to continue with the membership. There's pretty strict disclosure requirements about certain rights related to cancellation. And then New Jersey recently passed an updated auto renewal law that requires fitness clubs to allow cancellation by phone, in person, or online if sign up was completed online. And then there's certain circumstances in which a lot of these laws require penalty-free cancellations if the member moves or other events occur. And then a lot of these laws will also require renewal notices, typically 15 to 30 days before the renewal. These laws also might include a lot of other requirements unrelated to auto renewal services, like registration or bond requirements, which we're not covering here. And then just to briefly cover, we want to go over some of the key compliance requirements to help make sure that you guys are aware of the obligations that you might have under state and federal law. So the first major spot to look at is that you need to make sure that your sign-up process complies with state and federal law regarding what needs to be disclosed and how it needs to be disclosed. Again, as I noted, state laws might vary a little bit, but there are usually some common themes here. So when a user signs up for a product or service with an auto renewal feature, most laws require both disclosure of the material terms and express consent to the auto renewal. As occurred in the Adobe and Amazon and Uber cases, the FTC alleged that there was no express consent simply because there was inadequate disclosure of certain terms. And so it's really key to make sure that there's good disclosure of these terms. Material terms usually include the fact that an auto-renewal feature exists, the price at which the feature will auto-renew, the cancellation policy, and the length of the automatic renewal term. These terms have to be clearly and conspicuously disclosed, which is usually a contextual analysis that's based on the entirety of the sign-up process. And so, yeah, it's just key to make sure you're going through that process. For express consent, you need two key factors. You need reasonable notice of the terms, and you need unambiguous assent. To do this, you need to abide by the clear and conspicuous disclosure requirements, and you need to make it clear to consumers how they consented to the terms, either by signing a contract or by making a statement by clicking a particular button, you are agreeing to the terms. If the terms are available by hyperlink, you want to make sure that those are pretty, that the hyperlinks are obviously hyperlinks, usually by making them blue and underlined. And you want to make sure that the full terms are readily accessible to the consumer as they agree to the contract. So then I also wanted to go through a little bit what it means to have a clear and conspicuous disclosure, because that term comes up a lot. As I noted before, this is a pretty contextual analysis about how the whole sign-up process looks, whether it's on the phone, in person, or online. But the key is to make sure that a reasonable person would not miss the disclosures about material terms like price. The FTC in 2013 issued their .com disclosures guidance, which is a pretty key document for understanding what the FTC uses to define clear and conspicuous. Different states might have different definitions for what it means, but a lot of states will use the California definition, which just basically requires that the text is set off from other text on the screen. There's a couple of key factors to keep in mind. First, you want to think about what medium is being used for sign up. If it's in person, over the phone, or online, what constitutes clear and conspicuous is going to depend a lot on that medium. And so if the disclosure is over the phone, you need to provide a disclosure that is also over the phone and on the same phone call. For written disclosures, you want to consider the font size, which should typically be within 2 font sizes of the next smallest text on the screen, the font color, which should be at least as dark as other font on the screen, and set off in a bright color for hyperlinks. The disclosure should be spatially and temporally close to the offer. The screen should be uncluttered and not overly distracting. If there's too many other things going on the screen, courts often hold that it's not clear and conspicuous, and all disclosures should be in readily understandable language and not in legalese. And then for cancellation, you want to make sure that you are looking at your cancellation process and making sure there's not too many roadblocks for cancellation. Typically, you want to make sure that your cancellation method is easily accessible for users, and you want to make sure that there's not too many steps in cancellation. As we noted in the federal actions and in the state laws, there's usually a pretty clear focus on how many steps it takes to cancel, and often the FTC will include steps to find the cancellation method as part of the process. We generally recommend that users can cancel in approximately the same number of steps that they signed up, and you can typically provide at least one save offer, but if you provide too many, it could unduly lengthen the cancellation process and be subject to scrutiny. And then importantly, it's important that all future charges stop as soon as a user cancel. There's a few other key terms, but I think we'll move on to the last section.
Great, thank you so much. So before we turn to any questions, we did want to give you a few final takeaways on best practices. Number one, obviously, be mindful of the ROSCA requirements. And as Caitlin mentioned, it is interesting that even though the negative option rule has been vacated, at least for right now, the states are looking to the negative option rule for key definitions and requirements. So you need to keep abreast of the state requirements because they may differ from what is now required under ROSCA. This is an area of growing regulatory and litigation risk. We do a lot of compliance work with brands and other companies to ensure that all of their subscription practices are buttoned up. So to the extent you have questions, consult with legal counsel about the requirements. Next slide. So, in addition to compliance work, we do a lot of work helping companies respond to FTC subpoenas and civil investigative demands. So, I wanted to kind of go through some of best practices in terms of complying with the CID and what are the immediate steps you need to take when you do get a CID. So immediately after getting a civil investigative demand from the FTC, you should contact counsel. The civil investigative demand typically at the FTC is signed by one FTC commissioner, and it has several deadlines that are somewhat immediate in terms of responding and contacting the Federal Trade Commission, including a main confer concerning the specifications must usually happen within 2 weeks of receiving the CID. So that's why we usually work with companies right away to ensure that we meet those initial deadlines as the FTC articulates in the notice. Companies should also preserve evidence and working with outside counsel to do that. That companies always have the ability to file a motion to quash, which is a request to limit the FTC specifications or the CID altogether. However, those are usually not granted. Companies are usually not very successful in moving to quash FTC CIDs. And the other issue to consider is that moving to quash will necessarily make your CID public, which is a disincentive to move to quash. FTC CIDs are usually non-public and allows you to work with the agency confidentially, but moving to quash would be a court filing, in which case your CID would become public. Once we do work with the FTC and the companies, we do a lot of advocacy at the front end to frame and narrow the requests to try to avoid burdens associated with responding to the CIDs. Next, there will be after the initial period, you would set a schedule with the FTC in which to produce information. There is usually a deadline stated in the civil investigative demand on the front page, but that deadline is typically just for the initial production, and you could typically negotiate with the FTC to have a rolling production, so not all of your documents and information would be due right away, which is usually a month after the CID issues. Importantly, when I was at the commission and handled process reform, we changed the FTC CIDs to provide more transparency to the CID targets in terms of the type of investigation the FTC is conducting. So if you do get a CID on the cover letter and also inside the specifications, it will now state the type of conduct the FTC is looking at in particular, whether it's a subscription issue or a false advertising issue or a rule violation. At least you get some understanding of what the FTC is looking at. Previously, you were just trying to go through the specifications and trying to figure it out yourself. So at least there is some clarity at the front end for CIDs. There are some other things you must consider, including confidentiality considerations, your relevant custodians, your litigation hold. And then we work a lot with companies on factual diligence to ensure that we own the record and we understand everything that's going on, and we're able to strategically narrate that record to the FTC to ensure that we get our defenses across, even when producing documents and other information pursuant to the CID. And finally, early advocacy is key you know, I know some folks just want to produce things right away just to make the FTC go away, but our advice is not to blindly produce information to the Federal Trade Commission. You always have to have some strategy and advocacy in mind before you do so, because giving the agency what they want will definitely not make them go away because they are looking to bring more cases even in this administration. So with that, it is 2:45. I wanted to give folks time for questions. Happy to take Q&A. And thank you for listening. We look forward to being of service and helping folks out if you have any questions. And thank you again for the opportunity to present.
Thank you so much. We do have a few questions in the chat. First and foremost, I appreciate the response already submitted regarding California and New York's laws particular. And a lot of the questions, or several of the questions in the chat, do pertain to that immediate termination of payment requirement, which is largely what we have been basing our advocacy around due to the third-party transaction processing. Many in this industry have terms in their agreement that specify a specific date during the month at which cancellation is required in order to not receive another month of billing. And so first and foremost, are those terms in violation of ROSCA as it stands now? And ultimately, as you look to laws like California and New York, where there might be a provision in agreements with members between their facilities and the member that say any cancellation requests need to be in by the 15th of the month because the charges are transferred on the 16th. Are those defendable as they stand now, or how should companies be preparing and considering those?
I could take the federal side and maybe Kaylin wants to take the state side. I think if you are clearly disclosing those terms in your agreements for ROSCA purposes, I don't think that would in itself be a violation of ROSCA, so long as you're clearly articulating what the client's obligation is and those terms aren't buried in 50 pages of text. So long as there's some clear and conspicuous disclosures of those provisions, I don't think having those provisions within itself is problematic under ROSCA. But Kaylin, you want to handle the state side?
Yeah, I think it's basically, my understanding is basically the same at the state level. You need to make sure that consumers know about that. And I think that it really helps in a state investigation or in a lawsuit to make sure that you have a clear explanation for why that time period is pro-consumer, makes sense from a business perspective, isn't just an attempt to put a roadblock to cancellation or prevent cancellations. I think that you can build a narrative about that and how it works, and that can really help.
Great. In terms of a specific example, if a facility allows online signups, which require a new member to fill out a form and enter billing information, and their terms of the agreement are month to month and allow for cancellation via email, does that seem to be in compliance with ROSCA as long as everything is fully disclosed?
So first, just to disclaim that we can't give you all legal advice because we're not your lawyers, but in terms of just kind of generally, I mean, I think it depends in terms of how fast you process cancellations via email, and kind of the customer service element involved in that email communication. The FTC will be looking at, as Kaylin said, roadblocks, or if you don't check the incoming emails quick enough, and then you don't process the request fast enough. The rule is it has to be as simple as sign up. One argument is email maybe not as quick as online, but if there is kind of immediate or close to immediate response in terms of, yes, we receive your cancellation and we'll process it before you're billed, I think that's a good fact to have in terms of reasonability. Kaylin, I don't know if your answer is different on the state side.
No, I don't think the answer is different. It may be a little, you may have some difficulty if it's just email sign up and it was like an online process. In like some states, they do require you to offer online cancellation. So I think California does, New Jersey does. And so you may just need to be able to present why that is also online cancellation. I think that could be difficult depending on what the email process looks like. But I'm hesitant to say for sure without knowing all the details of the
Particularly
process.
in New Jersey, I know that that was something that HFA heavily engaged on in the process of the drafting of that law. And we were when in our conversations in the drafting and amending of that, it was understood by the policymakers and the sponsors of the bill that email cancellation was a part of that online cancellation process.
Yeah.
Okay, going back just to the 30-day, I think there's still some unclarity, specifically with California and New York, if it expressly prohibits a 30-day cancellation requirement. And if I understand your answer, Kaylin, correctly, as long as it's clearly expressed what the agreement that the member is signing into is communicated, it doesn't expressly eliminate as long as it eliminate the usage of that 30-day cancellation period.
Yeah, I think that that's correct. I don't think there's a provision that expressly prohibits that. I do think that you could run into roadblocks with an aggressive regulator or an aggressive private plaintiff arguing that that is just a roadblock to cancellation under those laws, and that it's unreasonable. But I don't read the law to expressly prohibit that.
Another question here. You had mentioned the multiple saves and the hurdle that that creates, and that being something targeted. I just want to clarify, understanding that you are talking about multiple times of a save offer, not multiple save options that are communicated in a simple format.
Yeah, I'm really talking about when you have one save offer that comes up and you reject that, and then another one comes up and you reject that, and another one, right? If there's multiple in one screen or something like that, I don't think that would have the same problem. The express language in the California law is that if you can have a save offer doesn't count as a delay to cancellation unless, but you have to allow a prompt cancellation on that save offer. And so if it's multiple save offers on the same screen, I think you can offer prompt cancellation. But if it's, multiple throughout the process, I think whether or not that's prompt becomes a more difficult question.
A last question just on time on potential appeal by FTC and what that means. What does that Svetlana, what would that process entail if FTC did make the decision to appeal the vacation or the vacating of the final rule? What does that look like in terms of the courts? And then ultimately, just what do you gauging the interest of the current commission, do you foresee or crystal ball in the possibility of a new proposed rule being pursued?
Yeah, good question. So, FTC has until August 22nd, in which to file an appeal. We're waiting to see what the FTC does there. On the one hand, um, the FTC supported the rule during the challenge, right? So if you're looking at that fact, you might say, well, they're going to file an appeal because why would they have gone through that motion originally if they were really kind of standing behind the rule 100%? However, given that, both Republicans dissented on it and they were very strong in terms of process fouls of the Biden administration, and given the issue presented on the appeal, which is submitting the proposal for a initial regulatory analysis and not some other substance-based defense, right? I think it is less likely in my mind that the Republican commissioners would take that issue um, up to appeal. I mean, this is just based on my understanding of their key priorities and the importance of following the process and ensuring that, you know, the FTC follows the law just like any regulated entity. So, I don't know. So like I said, less than 50-50 shot they're going to appeal, but that's just this is my reasonable intuition based on the facts. I don't know any information. Now, will the FTC promulgate a new rule and take out the parts they didn't like and perhaps do a narrow rule defining with more specificity what easy cancellation methods is? I just don't know if that would be the top priority given the executive order mandate that's 10 for one. So this would count as the one, and then they would have to identify 10 other rules or regulations to rescind or revise. I just don't know if they were going to put all of their eggs in this basket. And so I think given the fact that ROSCA is also anti, deceptive subscription, and they could do so much with ROSCA that I don't know if I were there, I'd be using the FTC limited resources to promulgate yet another rule, go through the MAGMOS process, given other priorities the agency may have. So maybe not, but you never know.
And then, Caitlin, sorry, again, just one quick clarification on the 30-day, maybe to put it in an example. So if a club specifies that, cancellation requests must be in by, say, the 15th of the month, is the club required to then end that termination on the 15th as with the immediate and at will clauses of that California law? Or can the club enforce its 30-day cancellation provision to seek the extra billing period?
So I wanted to say that I wanted to go back to this because I was going back through, I needed to refresh myself exactly where we were on the California law and 30-day notice requirements. I actually do think that they're relatively risky given the sort of like cost-effective, timely requirements in the law. And I'm sorry for getting that a little confused. I've been looking at a lot of these state laws in the last few days. I think the biggest issue is especially if you're going to charge somebody again after they attempt to cancel, that's probably going to be considered a delay in cancellation that is going to create some risk under California law. I think if it's disclosed and there's like a good reason for why you need that, but 30 days is sort of a long time, and I'm not sure if there's always a good reason for, because we work sometimes with some companies where it's like there's a cancellation limit for like that month if like we've already shipped out the goods, but it may not be clear what that explanation is for cancellation for a healthcare entity. I am looking at this specific question. I don't necessarily want to advise specifically on when cancellation should happen in this scenario, just because I'd want to make sure I'm looking at the express terms of the law and want to feel very clear on what I'm saying.
Right, understood. Well, thank you. This has been extremely helpful. One of that's the last question in the chat. One thing that I would love attendees just to be aware of is that HFA is actively advocating as these laws are introduced throughout the process across all 50 states. And we've actually been doing some work. We just recently had a win specifically around that 30-day cancellation time period in the state of Minnesota that we proactively went back in to roll back that provision this year, and we're successful. So we will be working to look at states like New York, California, and others that do have these laws on the books and seeing if there is opportunities for us to make changes to the laws now that they've had time to mature and are enacted. So stay tuned on more of that as we head into the legislative sessions for 2026, and stay engaged with HFA because we will be looking at everything that we can imagine. There'll be an onslaught of laws introduced across the board over the next session in states that were pointing to FTC and the click to cancel law for taking the helm. So with that, Liz, I saw you came back on camera. I'm not sure if there's any closing remarks that you'd like to make, but I want to specifically just say thank you to Svetlana and Kaylin for your time. This has been extremely valuable and helpful for our members.
Yeah, Mike, I just wanted to echo that. Thank you both so much for your time, for informing us, and thanks so many of our members for joining. And thank you to Mike for leading this. So this was great.
As a reminder, a recording will be made available for our members, and we'll be sending out communication. But also, the team at Gibson Dunn will be sharing their contact information so that they can help with any ROSCA related questions or any issues that your individual companies that may arise in the future. So, with that, thank you both so much for your time. Thank you everybody for your attendance today. If you have any questions or anything that we can be helpful with, please don't hesitate to reach out.